first week of on that community.
Hopefully you have any applications for the Central Board.
And
The Central Planning Board, did you hear about that one? Is that a guy who's been on the board, doesn't live there?
Oh, really?
You've been in South Carolina, you need to hold up, because I've been bringing up some of the things that they broke up, that they weren't people who've been staying on the board. Hasn't been risen, it's losing powers.
Sure, that's right.
That's Newark.
In accordance with Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, be advised that a notice of this meeting was made by posting on the bulletin board, town hall, and mailing to the officially designated newspapers a list of the meeting dates annually, indicating that this meeting, which is a special meeting, would take place at the town hall at 7:30 p.m. on Wednesday, July 12th, 2013. Roll call.
Allison Canfield,
Here.
Michael Cohen,
Here.
Maggie Miggins.
Here.
Deborah Nevis.
Here.
Sujata Shan. Here. Srini Vijay.
Here.
Michael Zion.
Here.
Vice Chair Gaston Halbert.
Here.
Sharon Fetzel.
Great, our first order of business tonight, we have approvals of meeting minutes, 2 sets of minutes. The first one, let's begin with May 17th, 2023. It was circulated a few weeks back, and then today we received an updated version. Was it redlined, Eileen? I know you mentioned the lines which had the changes.
a small paragraph. There were a few comments that I just put in.
That you incorporated into the other paragraphs as noted in the email. Did anybody have any further questions, comments, or revisions to the May 17th meeting minutes? I move to approve the minutes of May 17th. Do we have a second? Second. Allison, great.
Allison, you were not there.
Allison was not there.
I don't have.
Deborah can second.
Oh, yeah. I forgot what date it was.
Yes, that's fine. Thank you. All in favor?
Chair, one
Oh, I'm
comment.
sorry, Gaston.
No,
Sorry.
that I read it today and I'd like to find it. I don't know what line it is,
This is the May
Aqua
17th
Tots,
minutes?
Yeah, facility would operate from, not form.
Oh, is there a from to a
Yeah,
form?
just a minor comment.
Can you state what paragraph or any? How far down is it?
Second paragraph after the entered as exhibit A3 elevations,
Okay,
second sentence.
Got it.
thanks. With that single change, do I have to motion?
I would.
I move to approve with the change of form to from.
Second.
All in favor?
Aye.
All opposed? Those not present, recuse. Meeting minutes of May 17th, 2023 are approved. Second set of meeting minutes was the one from June 7th, 2023. We only received the initial version. I don't think there were any additional comments or corrections. Did anybody have any notes? I'll move to approve the minutes of June 7th. Do you have a second?
I'll second.
Srini, great. All in favor?
Aye.
Any opposed? And those not present, recuse. Great, meeting minutes of June 7th, 2023 approved. We have one memorialization on the agenda for this evening. This is application 23003, the Tonino Cigars, which we received from Kathleen?
Yes.
From Ed's office for review. Did you receive any comments
I
or
received no
corrections?
comments. or
And do you have any
corrections.
comments or
I have nothing
corrections?
further.
Okay. Did anybody have anything further? Do we have a motion to approve?
Motion to approve.
I'll second.
Who was that?
Srini?
Allison Canfield.
Yes.
Michael Cohen.
Yes.
Maggie Miggins.
Yes.
Deborah Nevis.
Yes.
Sujata Shan.
Yes.
Srini Vijay.
Yes.
Gaston Halbert.
Yes.
Fetzel.
Yes. Memorialization application 23003 is approved. We'll move on to our final order of business tonight, application 22 2003. The matter carried from our most recent June 21st, 2023 meeting, Annie Milburn Partners. And tonight, we are charged with board finishing the application and taking action. Before we begin, I know we received some communications from Ed as recently as today, and I don't know if that's something that you want to state for the record or
I
anything
would.
else. Okay, I turn to you.
Thank you, Madam Chair. For the record, there are a couple items I would like to put on the record. One is I sent a letter to the board setting forth a review of the requirements of the settlement agreement, the ordinance, the regulations, as related to the integration of affordable units with market units. I also had a conversation with Josh Bowers of Fair Share about the integration. We had a relatively lengthy conversation. He was generally familiar with the layout. I explained to him the details, including the 15 units on the ground floor, the location of those units, and then the stacked 5 units on floors 2, 3, and 4. Again, he was familiar with the layout. His position was that, and I put this in the email, and I just want to put it on the record. With his permission, I told him I was going to do this. His position was that while this may not have been the optimal integration of affordable units to market units, Fair Share would not challenge any approval of that plan that the planning board may grant. And he authorized me to convey that to the board, so I did in my email. I subsequently requested that he confirm that in writing. I followed up yesterday again. And today at 2 o'clock this afternoon, I did receive a confirmation from him in writing, which I did distribute to the board members and the professionals about 4 o'clock this afternoon. And and he confirmed effectively what I had related to the board, that they were comfortable with the integration plan presented by the developers. And he noted in his email confirmation that it is generally consistent with the manner in which 249 Milburn Avenue had presented these items in the concept plan, and then expressed the excitement of Fair Share to have these projects move forward. So that's the first thing I wanted to put on the record. The second is that I subsequently, and actually the same day, on Friday, later that day, sent a confidential email to the board under the attorney-client privilege, in which I just provided the board with a framework or outline or structure by which to evaluate the site plan, reviewing the various materials which form that framework, and including the municipal land use law and general case law and so forth. The purpose of that was simply to remind the board of the parameters under which it works and the statutory and regulatory requirements under which it works. That will not be disclosed tonight, but I did want to put on the record that I did give the board that advice in closed session in a confidential letter. With that, Madam Chair, I'm finished. I'll pass it back to you. Thank you.
Thank you. So we concluded our last meeting with the agreement that materials would be distributed. Eileen did that, I think, 2 days after, the day after our last meeting, electronically. Go ahead.
Can I ask Ed a question?
Oh, yeah.
When Josh from Fair Share Housing says generally consistent, how is that?
I'm sorry, I didn't hear.
When Josh from Fair Share Housing says generally consistent, how does that get interpreted?
How does it get?
How do you interpret generally consistent? Like, is that,
Well, the concept plans were concept plans. They were not detailed. And now what we have before us are still not construction plans. These are more detailed plans. So, I would interpret that to mean that if you start out with a concept plan and then you sort of drill down into a more detailed plan, that what you see in a detailed plan was generally consistent with what was in the concept plan. I mean, that's the way I would interpret it, but others may look at it differently.
Can I ask Mr. Petto something about this? Mr. Petto, Mr. Bauer says in this that, again, the consistency here is a little concerning, is generally captures. Does it capture or doesn't it capture? Are you pregnant or aren't you pregnant? You're one or the other. You can't be both. So the question is, he says in this, the integration plan is generally consistent with how 249 Milburn Avenue presented things in the concept plan that is attached as an exhibit. Can you share with me that concept plan? Does that concept plan lay out every single affordable housing unit on the ground floor?
In reviewing, we took a look at this, when the application was initially filed for preliminary review back in September of last year. Our office did take a look at the concept submission. There were low and moderate units depicted. As far as the copy that's included with the settlement agreement as an attachment, the low and moderate units were indicated on floors 2, 3, and 4. But low and moderate units were not indicated on the first floor within the concept plan, as the version that at least is available with the filed.
So the version that's
settlement
available
agreement.
does not show the concept. The concept plan does not show the low and moderate units. There's 15 of them on the ground floor. And that's what Mr. Bowers is referencing in his email. And I might put that it's not on letterhead, it's an email from him. It's not from the Fair Share Housing Center, it's just his email. So I want to put that on the record that although he sent this email, and that's great, it's still, that concept plan doesn't show those 15 units. And then also, thank you. Also, for the record, Fair Share Housing Center is excited for this development to move forward as it will be among the first inclusionary developments. That's not true. That's not true. The Upton is an inclusionary development. We've approved Beehive and the Woodmont properties that are both in construction. The township has also approved the 75 units. So this will be the 5th, not the 1st. So I think we have to go on record in saying that that's not true.
I think he didn't say it's the first, he said among the first, like among the first set.
Yeah, it's,
Well,
please. That's how I feel and that's how I've read it. So that's just my feeling. And I think to get this at 4:00 in the afternoon, 3 hours before we're supposed to have a meeting is poor form. I just do. And I myself feel that this should have been, again, I have twice asked for information presented. And Eileen, were these revised plans directly provided to our board of professionals for review and updates for comments? These that you sent to our homes, were these directly provided to the planner?
I don't know that.
Mr. Petto, did you get these?
We did not.
You did not. Okay, so they didn't even receive these.
Yeah,
So
for the exhibit. I
I-
wasn't asked to.
I appreciate, well, but for comments, we have to be able to have comments on this. So for me personally, I think there's a lack of integration on these fair share units. And I think that the information provided had mistakes. And I repeatedly asked for more updated plans. These plans that are, I could show you, they're highlighted, they're incorrect. And I personally don't feel comfortable signing off on this at all this evening myself. That's my own personal opinion. And I move that we deny this application.
I'd like to second that. I, at this point, feel that it's not complete.
Speaking of Mike.
And one of the questions.
Yeah, they can't hear you.
Okay. I'd like to second that. And the reason, I have a few questions as to, again, what was just pointed out. I also looked up the fair share housing piece and what was the original agreement, preliminary agreement. And in my mind, it does not match. So I'm struggling with this and looking at the comments that were made. So I just do not, and I don't want to say complete, it just is not, it's insufficient to make an informed decision in my mind.
Okay, so we've now had a motion and a second as a board. So does that mean we would have to be, I just want to make sure we're following procedure.
Well, I think there's discussion that the
Yeah.
board should have.
Yeah.
And I'd like to at least start it out, if I might.
Sure. Yeah. I just don't know if we have to take action on what was just done. So.
No, I
Okay.
think this is all part of the discussion. Eventually, you will have to vote.
Okay,
You have-
great.
You have a motion and a second on the floor.
Okay.
So eventually, you will have to vote on it. So that will come.
Okay.
Several things. Number one, if the board or members of the board are uncomfortable or feel that the application is not complete or that there's outstanding questions, it would seem to me those questions should have been raised during the course of the hearing. And I'm not being critical of anybody. I just want to put this on the record. A denial of an application of this nature, which is fully conforming, except for this issue of the stoops and non-stoops and the variance that may or may not be needed depending on how the board comes down, needs to be justified, and it needs to be justified specifically, not generically that there's something, you talk about the completeness, and again, I recognize you pulled back with that, so not. But I don't know. I need, and I think the board needs details as to what is it with this plan that is not consistent with the ordinance, that's not consistent with the settlement agreement, that's not consistent with the land development ordinances. Where are the deficiencies? What's the deficiencies? And it's not deficiencies that, well, I don't like this, and I'm not suggesting anyone has said any of this. I'm just trying to give examples. It's not, well, I don't like this, or I think it's too intense, or I think I don't like the way it's laid out, and it should be laid out differently. There needs to be specifics. There are a number of issues that the board dealt with and raised with the applicant, and one of them, one of the big ones, was traffic safety. And you will recall that, their expert had no problem with any of the traffic, any of the ingress and egress, any of the safety issues and so forth. Our police department raised an issue of concern. Our engineer raised an issue of concern, our township engineer. We went out, we retained an independent expert for the township, that's the township's traffic expert, to review the report that was done, to provide comments, and to also opine as to certain other elements, which was the safety issue, ingress and egress, which is within this board's jurisdiction, which was questioned by the police department, I think initially questioned by the engineer, in the sense of there were concerns about it. We did that at the expense of the applicant, which they're required to do under the ordinances that we have. And we had our expert come at the last meeting. Before that, Mr. Penke from the applicant's traffic engineer responded, albeit late, but everything was done as quickly as it could be done, I think. But he responded in writing and then testified at the last hearing in detail about his response to Joe Fishinger's of Brightview's report. And then Mr. Fishinger testified, indicating, as I recall, and my recollection could be faulty, but my recollection is that our expert ultimately had no problem with the safety issue. We had a speed study that was done by the police department. There were additional traffic counts and so forth. So when you look at the facts that are in the record, the traffic issue, the traffic safety issue, has certainly been exhausted. It's been addressed, it's been exhausted. And both the applicant's expert and the township's expert, at least as I recall from the township's expert, were in agreement that there were no issues that they needed to deal with. Now, they did talk about the potential of creating a stop sign instead of a yield sign on a left-hand turn from Lilburn into Essex. And my recollection is the applicant's position was they didn't really care. Essex County was, if that was acceptable to Essex County, they were fine with it. There's an issue about crosswalks. Again, I think their position was if the county allows it, we'll take care of that. So that was the traffic issue. You then look at the sewer issue, sanitary sewer issue. That was, I believe, addressed both by their engineer and our engineer. You look at the storm sewer issue, that was addressed by their engineer and our engineer. So if the board's going to move in the direction of denying an application, they need to set forth the basis for that denial. And it needs to be specific because I need to put it in the resolution. And there needs to be facts in the record to support that determination. And I would strongly urge that if the board is going to move in this direction, that they articulate in detail what are the problems with this and how those problems inconsistent with the documents that I talked about. The zoning ordinance, the land use ordinance, the settlement agreement, and the application itself. If you want to question our professionals about certain things, you certainly can do that. That's what this deliberation is about. And hopefully they will be able to answer any questions that you may have, or be able to put other things into context. But I would strongly urge that if there is going to be a denial, that it not be done solely on the basis that has been articulated thus far.
If I can, sorry, go ahead.
I'd like to speak. So I also have reservations about the application, and it is not based on the two issues you cited, of traffic or the sewer. What it's based on is the placement of the affordable housing units. I'm concerned about what precedent this sets for future affordable housing developments, which we know are yet to come before the board. I know that I don't think I'm divulging anything, but in the memo you sent us, you said there's no objective standard for this. But it made me think of the famous Supreme Court case on obscenity, where Justice Stewart said there's no objective definition for it, but I know it when I see it. And as far as the affordable housing units being clustered, that's how I see it. I see that they're clustered. They're in the least desirable parts of the building. The people have to walk outside to get to the front door, to throw away their garbage, to get their mail, all of those things. That disturbs me for this unit and for the future and for future units, that they'll be, that they'll do the same kind of thing. So I think that's pretty specific, and that doesn't require speaking to any of our township experts, but that's my reason.
Can I comment?
Sure.
If I might.
Sure.
I just don't want to lose the trend of thought. So
That's fine, please. No, go ahead.
You've raised a good point, and let me approach it from a different perspective. The motion that was made was to deny the application, and we're now talking about reasons. You mentioned that I think the mayor and you mentioned the affordable, the layout of the affordables, and perhaps other members of the board, despite the fact that Fair Share doesn't seem to be concerned about it. You're concerned about it, and I'm not. That was not meant to be a sarcastic remark. But my point is this: you don't have to deny an application because the layout of the affordable units is not optimal or is not the way you feel is appropriate. The way to handle that is to impose conditions on the approval that would require whatever it is you want. So if you want those affordable units in the, I'll call it the wing, to be dispersed elsewhere in the building, or have one there instead of 5, I think, are on that side. That would, you don't throw the baby out with the dirty bathwater. If you have a concern with that, then articulate that concern and impose that as a condition of approval. Now, if the applicant doesn't like it, the applicant can challenge that condition of approval. But it's to deny the application based upon a component of it that, in this case, and this is just one, there may be several of them, that can be addressed through a condition, is not the appropriate way to deal with the application.
But Mr. Buzak, we asked them on every meeting to make a change on these, and they chose not to. So
I
now at the
understand.
11th hour, when we say no, we'd like to deny it, because if you look, the application does not comply with the affordable units being integrated with market rate units throughout the development. They've known this from the beginning of time. And 50% of the units are on the first floor of the building. And then there's another 14 market rate units with them. So more than 50% of first floor contains affordable units. And so the other 27, I mean, those are segregated. Those are absolutely segregated. And then the rest are put in clusters, which is more segregation. And the planning board has demonstrated time and time again to accept these type of applications. Look at Beehive, they're fully integrated. Look at the Chatham Road project, that's fully integrated. Look at the Upton, it's fully integrated. And we continually asked them to make those changes, and they said they didn't have to. And that they thought that they just didn't have to, and it's part of what they signed off on in the settlement agreement, 7D, Section 3. I mean, they signed off on that they would fully integrate these units, and they chose not to. And that's not right.
I want to let you finish, but I want to
Well,
respond.
that
to
was one thing, I think that's really important. I really do. And also, listen, I sell real estate for a living. I look at floor plans all day and every day. Every time I continually ask our planning board, our planning person, Grant Petto, asked for updated plans back in September. We've never received them. And then what was sent to us was still incorrect. That's not acceptable. So we have plans that are incorrect that you want us to vote on. And the same thing with the housing. And as far as fair share, they should have put something in writing on letterhead saying that they were completely okay with the segregation of these units. Because that's what it is. It's pure and simple profiling and segregation.
So I guess you're allowed to have that opinion.
Sure.
I don't want that stated on the record as the opinion of the board because
No, it's the
you
opinion
are
of, it's my
strictly speaking
opinion,
for
it's
yourself.
Maggie Miggins' opinion.
I also do want to remind us all that we heard testimony, we brought up this concern as a board, oh, look where they are. And they provided testimony talking about what it was in the hallway, how the units are. I listened to you and please listen to me too. They provided their testimony. They did acknowledge that, yes, they were clustered on those 5 units on the one first floor section, but so described how they were integrated throughout, how they were not all just the whole first floor entirely. And so I hear what you're saying and I understand there are, maybe call them clusters or pockets or whatever. I'm not comfortable characterizing it as segregation/discrimination, which sounds like there has been some positing, and I'm not comfortable with us saying that.
And that's your opinion and you're entitled to it, but that's what I consider it to be.
Deborah.
Ed, can you walk us through you're saying that we can impose conditions on the placement of these units. Can you walk us through how that would work? What it would look like? And what the outcome would be, if the applicant chooses not to follow through on that? Can you just, because I don't know,
Yeah, I will try. If the concern is that, for example, the 30 units should be essentially equally distributed among the 4 floors. Again, it can't be equal because it doesn't divide up right. Then that could be imposed as a condition. In other words, that the application is approved subject to the applicant distributing the affordable units, no more than 8 units to a floor, or whatever. You can go further than that if these are concerns you have that they should be that there could be no more than 3 units contiguous to each other on any floor. The point is, and this was the point in my email. It is a subjective standard. There's no formula that you look at, and to Mr. Cohen's point, people can look at different things and well, Justice Stewart may know it when he sees it. I'm not sure everybody knows it when they see it. And what they see may be different to, depending upon their point of view. So even with this, when you're talking about integration, if you just turn around and say to the applicant, we condition this upon submitting an acceptable or an improved integration plan, you're not giving any direction. That's they submit it and somebody says, whether it's the board or whatever, says, well, no, that doesn't do it. So what does it? What is it? They're putting 30 units in, where do you want it? And I know you can say, well, wait a minute, that's not our job, but I submit to you that it is your job if you're going to look at what's been presented to you and say, that's no good. Well, you have to tell them what's no good about it. And then you have to give them some direction. And if they don't like that, they can challenge it. But
And what happens then? What does that mean by challenge?
well, what they do is, let's say you approve the application, subject to a condition that the applicant distribute the affordable units essentially equally on 4 floors with no affordable units, no more than 2 affordable units contiguous to each other. Okay. The application's approved. The applicant's got to decide, okay, can I do this? How can I do this? Can we move something around? Or the applicant's, you know what? I don't have to do that. I take the position that the manner in which we proposed it satisfies it. I have an email from Fair Share that says it's acceptable to them. But it's not acceptable to the Millburn Planning Board. I'm gonna put that before a court. And let the court decide if Fair Share is okay with it and we're okay with it, we're the applicant, it's the board that's got the problem. And the court may say, well, yes, that's true. If Fair Share is on board, we're okay. Court may say, well, you know what? Millburn's got a point here, and I understand what Fair Share says, but Millburn's concerns are valid concerns, and I'm going to sustain the condition. And that's it. And it's you either get it or you don't get it.
Right.
But I can almost assure you that if you deny an application based upon that, the court will not sustain it.
But we have history where we haven't denied applications and where we've approved them. And we've approved them where the units have been equally dispersed throughout the building. We have that proof. So I think the courts would look at that as well and say, well, Millburn, you're right. You did it at the Upton and the Beehive properties and Woodland Road, because if you look, and I have that, the Wells Fargo application, which we approved, has 3 units on the 2nd floor and 5 on the 3rd. The 85 Woodland Road, approved by this planning board, has integrated its affordable units, 4 units on each of the 1st and 2nd floors, 5 on the 3rd and 3 on the 4th. They're fully integrated. The Upton is fully integrated. It's not that they're not stacked, we'll say at the Upton, but they are fully integrated. This is not fully integrated. And from the very beginning, this has been a problem for me.
So, I'm sorry.
Go ahead. No, well, my question was, can we just impose it and then let it go and then I guess we go to court if they don't like it? But where do we want the units? Let's
Well, and
put
also,
that as a condition, and then
it's an email from Josh Bowers, but tomorrow Josh Bowers might not be there. So where is it written on Fair Share Housing's letterhead that the head of Fair Share and all of Fair Share has approved that? That they themselves, that the Fair Share Housing Center approves the segregation of these units. You know, we have Josh Bowers is saying he was okay with it based on plans that didn't show all 15 units on the ground floor. So how can you even use Josh Bowers' letter?
Well, in fairness, I had that discussion with him, and not only did I lay out where the number of units that were there, but I also laid out exactly where they were, and he was familiar enough with the plans to know.
But that's not what he said, Mr. Buzak. And
Well-
we have to have that in writing from him or on letterhead or something. I'm sorry, he
Well,
said, she
I'm just
said.
relating to you what I told him.
I
That's-
appreciate
that's
that, but we weren't there, and I'm sorry. I'd like to see it in writing.
Madam Chair, so if I could ask Ed too, was Fair Share, or in Josh's case, was he asked if they would entertain a denial of this application if we were, because I think this is bigger than whether the planning board decides what segregation means. I think this is guidelines that should be definitely through Fair Share Housing, because we ultimately would be responsible if we are ever legally challenged because we decided what was, in our opinion, where it's a bigger issue where Fair Share Housing should have those guidelines as to how we should proceed. So there's a force here versus us deciding, because certainly what I think is segregation and what someone else feels is totally different. So I think it's lacking here in the fact that we should be asking some questions, and it shouldn't be up to the planning board as to what that means.
Well, let me.
Wait a minute, and one more thing,
No,
I'm sorry.
I thought you were finished.
This would mean we'd have to do it for every application because there is no standard set. So we would have to view every application that comes in front of us from this day forward and be responsible for the decision made that we made instead of what was acceptable by the guidelines of Fair Share Housing. That was my objection to this. I don't want to say incomplete, just insufficient amount of information to make an informed decision. I can't say that any more clearly. I totally agree that they've gone above and beyond with traffic and all that they've done, and I'm very grateful for that. The fact is, I think this is an issue that we have as a board in this Fair Share Housing agreement. And I think that falls, to me, on our professionals.
Give her a
I'm
response.
sorry.
No, she's asking you a question.
Yes,
Yeah.
okay. Fair Share, let's understand who Fair Share is here. Fair Share is not a regulatory agency. Fair Share is not an arm of the government. Fair Share is not an arm of the judiciary. Fair Share is an advocacy organization whose mission is to advance the cause of housing for low and moderate income households. They do not govern anything, nothing.
Well,
They don't create regulations. They don't establish rules. We don't live by what Fair Share says or doesn't say. And when I say we, I mean a municipality does not do that. When we proceed with what we're doing, we do it based upon what we, Millburn, and other municipalities understand the law to be. It may not be what Fair Share thinks it is or wants it to be, and that's what creates litigation, and that's what creates determinations and court decisions and opinions and so forth. And, you know, they vary. But I don't want the board to believe or have the impression that somehow Fair Share governs what we do. They do not govern what we do. We govern what we do. We have a settlement agreement in Millborough. We were required to do certain things under the settlement agreement that Millborough agreed with Fair Share. These are the things we're going to do. We did those things that created the ordinance that we're here. Now, when the applications come in, Fair Share doesn't have a say in this. They're not a party to this. If they don't like what we do, they can sue us. If the applicant doesn't like what we do, they can sue us too. And if a resident doesn't like what we do, they can sue us too. But we make the decision. We to cede control of actions of this planning board to any group, whether it be a group of citizens, whether it be a developer, whether it be an advocacy group, whether it be some other nonprofit organization that has a mission, is, in my view, a dereliction of the duty of a public official. Whether you're an elected official or an appointed official in a municipality, you have an obligation to perform that function, whatever it happens to be, to the best of your ability. And these other entities may have a lot to say, but at the end of the day, you have that responsibility. And I think it is, it's inappropriate to allow or suggest that some third party, whether it be Fair Share, whether it be some other organization, whether it be a citizens group, make the decisions that will then bind this board. I think that is something that is not the manner in which the board, any board, should exercise its obligations.
I just want to make sure that she feels responded to.
No, I thank you for saying that, and I think that to hear that, because I think what we have been hearing are a lot of threats and about what this can do to our town and all this other stuff. And reality is, we can make the determination of what we need to do and what's best for our town and not let a third party do so. So I appreciate you saying that. I wish you would have said that, before this whole thing started. So thank you.
Allison, if I may modify then what you're saying, given the way you just put that at, what I say is this vague email that we have from Josh Bowers notwithstanding, it's my opinion that because these units are segregated, it opens us up to the risk from either Fair Share Housing if Josh leaves or some other like-minded group to say that we did not meet our affordable housing obligation, but we followed we followed the letter of the law, not the spirit, whatever, haul us back into court over this project because the units are clustered. And I think there's a risk of that. And I'm not comfortable approving it in that with that risk.
And what condition, back to Gaston's
Yeah.
question.
Yeah, exactly. Let's tell them what we want, what we.
Well, the
How do
applicant
you
was
want?
party to the township's settlement agreement. They were aware of the ordinance requirements, including that the units had to be integrated in order to permit this development. The applicants know that these units are not integrated. These are not integrated. So the applicant is aware of it. It's all part of what we signed off on. It doesn't comply with the ordinance by not integrating them. So, and that is ergo the reason why I say to deny the application, because they weren't integrated.
Not necessarily that, but we don't want to deny the application. We want to work with them. So is it going to be 8, 8, 8, 6? How are we going to? This project isn't going to go through, right? It's affordable housing, but where do we want the units so they're not segregated? We have, I don't know how many, 5 on the top, 5 on the side, and then a stacked cluster. Where do we want them? Where is it going to be okay for us to say yes? We feel that they're not segregated. That's what
We
I
have to
think we need to ask.
look back at the plans and get feedback from our planner. That's why we have a planner. We'd have to get feedback from the planner who would think you
I
know,
think
that
we're equipped to make a recommendation.
I mean, it sounds like we don't have to say put one here, one here, one here, we can.
Your parameters.
I don't think we should be deciding that
Let me-
tonight.
Let me just finish. That we can be specific in terms of something like no more than 3 units contiguous, so it has to be broken up more. That we can say stuff like no more than, no less than 4 to a floor, whatever we wanna say. It sounds like we don't have to get into the weeds in terms of specifically saying where we want the units, but like that wing that has so many of them, we can say something about that. That's what I'm understanding from you.
That's correct.
So I agree, Maggie, I do think we should ask our professional. So I would
100%.
turn and ask you what you think of, Ed has just presented a potential solution tonight.
Well,
to us for the first
I
time.
have a question.
No,
I have a
Is that
question.
Can we let our planner speak?
I have an objection, if I can make the objection.
I think that we're now in deliberations,
Right.
Mr.
It's out of
Amos,
order.
so let
And to
us.
hear
let
testimony
us-
from your professional in deliberations is not appropriate, and I want that objection on the record. And if he's gonna testify, then this needs to be reopened for that purpose, and I want the opportunity for cross-examination.
He's
So
not
do I.
testifying, what he is doing is he's responding to a question that the board has raised as one of the professionals, just like I or Martha or anybody else here, so
Well,
I
Mr.
disagree
Buzak,
with-
with all due respect, you're the attorney, you're not, attorneys aren't cross-examined, you're not providing testimony as a professional in that sense that the board is relying on, right? We don't,
Madam Chair, he's out of order. This is board discussion. I am very sorry, but that gentleman is out of order.
I'm
He's out of
raising
order.
a
You're out of
procedural
order, sir.
objection, you're not the chair.
I'm asking the chair, I
I
believe he's
understand.
out of
I'm
order.
gonna allow him to make his procedural question. Can you please just ask it in the form of a question and then we as.
Well, it's a procedural objection. Again, John Inglesino, attorney for the applicant. If you're asking your planner for his testimony, for guidance, what should we do here? Then that's providing testimony, and I object to that because we're in board deliberations. And that's an objection. I do think that I do have a suggestion, if the board wants to hear it or not. I can confer with Mr. Buzak on a break. You can do it here, whatever you want. But, I do have a strong objection to hearing expert testimony from your planner in regards to the issue before the board.
Okay, I appreciate that. I'm not gonna have you provide a suggestion at this time. I would like to confer with our attorney, so I don't know if we would do that I just have questions for you, that. I'd
Well,
like to ask, so
we
should go to-
You raised the question with the planner. I
Now there's an
heard
objection,
Mr.
yeah.
Inglesino's objections. I disagree with it. I don't think that the planner is providing testimony. What the planner is doing is a question was raised over the course of deliberations. The planner has the ability to respond to the board, and that's what he is doing. So I have to disagree with him. I would suggest that to the chair that we allow the planner to answer the questions that we have. Just
Okay.
as if we would have one with Martha.
Thank you. Okay, so Graham, if you can respond to the question of not providing testimony, but you're just responding to the board question of this potential
I'm
solution.
mostly just going to concur with the conceptual outline that Mr. Buzak had stipulated of, specifying a number of units per floor, minimum and maximum, as you were alluding to, Ms. Nevis. And perhaps, also instituting controls on contiguity of number of units. I think those would be two metrics. I think that would help to kind of guide the applicant in their, evaluation of your opinion regarding distribution of units. So just really concurring with the framework.
Are there any other measures that we should be thinking about besides continuity and number?
Objection.
She's asking a question.
I understand, and I want the record to be clear, that when a planner is giving professional testimony, he is testifying, and that's what he's doing. He's giving his professional opinion to the board. That is testifying.
I'd like him to answer Deborah's question.
I think for clarity and ease of enforcement of the resolution, I think that that's sufficient.
Thank you. Allison?
So Graham, is it correct that you haven't seen a copy of what was sent to us am I understanding that clearly?
You're referring to
The
the
last copy from.
the exhibit materials that were circulated. No, we did not receive those exhibit materials directly.
And is that, in my opinion, the determination of where to put these units is based on the configuration of the actual building itself. And I'm asking you, do you think you could do that on the fly and direct in the next hour on how we should guide that or how we should request that?
I don't think we're asking Graham to do that, but
I think we just did, that we needed the guidance of should we propose, you know, would that be one of the or Gaston, you had mentioned, can we, you know, lay that out now to the board of how many units and all
You
of
just
that?
mentioned site planning, so that was where, so
I'm
in my
sorry.
mind, you
I'm
talked
sorry.
about like stipulating which units, and I'm saying I don't think we're recommending to do that, so we wouldn't need to get to the planning level, but if I misunderstood your statement, then.
Okay,
My response to that is I think the way that Mr. Buzak had characterized the condition, to be crafted to allow the applicant the flexibility to locate within the parameters that the board may set, I think is probably most efficient for them to do that evaluation. There are other components that impact location of units, building systems, other things. So I'm not an architect, so that's beyond my professional expertise to do.
thank you.
Mr. Buzak, just a question for you.
Thank you.
If the application is approved based on where the units are likely to be placed, and the applicant actually, agrees on that or disagrees on that, does the board have to come back and vote on the revised placement?
Well, typically not, and I would suggest that if you're going to go in that direction, that we establish the parameters that can be objectively evaluated. So for example, if we say, I forgot the numbers, 8, and 6, or however, or 6, 8,
Adds up to
8,
30,
8,
yeah,
whatever, they add up to 30. And no more than 2 contiguous to each other or whatever, that can simply be evaluated by the staff. Look at the plans when they come in and say, oh, wait a minute, we got 12 here, it's not 8, you're not consistent with the resolution. So that's the way I would do it. I wouldn't want it to come back to the board and look at it and go from there. I think that's an exercise we don't have to continue.
Okay, so Gaston has put out some, potential numbers or, kind of carrying that theme of what type of condition might we actually, set forth. That would give people more comfort and feel the integration is achieved, to your concern.
Right, and I'd also like to have something related to the contiguity of the units so that there's not no more than 3
No more than 3
units.
contiguous and
Say 2.
Two, that's fine, 2, okay.
do you have that condition captured? No more than 2 contiguous.
I got no more than 2 contiguous. I wasn't sure what the numbers were. I know they have to add up to 30, but it wasn't
I
sure.
guess there's like no more than 8 per floor.
There's 4 floors.
8,
7.
8, and 6. So you said no more than 8 per floor. Right, that would be the maximum, and then they would have to then be dispersed.
That still allows, for instance, on the main floor cluster, there's 7 units there, so it still
So you're
allows
saying
4
only
of
2
them.
can be,
Only 2 can be next to each other.
So you could put 2, then you could put a market rate, then you could put another 2. So in essence, you're still putting them all on the,
but that's meeting the.
It's only 888, right, 886. So you're still, it's more dispersed than what it is right now. Like you're grouping them in fives,
I just think-
and then stacking.
I don't think we can, I think we received, not just from Josh Bowers, but also, Ed provided like the 4, quotations or examples of definitions of integration, right?
but it's still not consistent, in my opinion, and that's why I objected to it. So there still is that motion on the floor.
But what do you want? Like, let us know, like, how do you want them dispersed?
Well, I don't have a problem with it. I think that some people should be on the courtyard, they all should. So the way the units are set up right now, you have a whole cluster segregated right on the ground floor, right? And these plans are incorrect anyway, they just cut and pasted, so that's why my objection to the plans, right, because they're incorrect. So let me try and find the ground floor, yes. So you have 1, 2, 3, you have all of them lined up here on the railroad side.
Yep.
And then you have all of them lined up here next to the dog run. And all around here, some should be in the courtyard, so some people should be able to be looking in the courtyard. They shouldn't have to be necessarily all on the street on the exterior. Everybody's listed on all of them are listed on the exterior.
I think it's subjective of what people prefer, I think
So then it should be a problem to move it. Because it should,
I'm saying you're arguing that the courtyard is better.
Well,
and
I
that
bet you
should
that
be
the rents
something.
are higher in the courtyard. They're just like if you live on a busier street, it's less expensive for real estate than it is if you're on a quieter street. If you live on a corner property, it's less money. You pay less money for a corner lot than you do for something right in the middle of it. So yes, I believe from my own background in real estate that these are the least desirable units, the ones that are on the ground floor that back up to the railroad tracks, the one that are on the ground floor that back up to the dog run and the parking lot, and the one that are on the main street. If that's not a problem, if they want to integrate them into the courtyard ones or mix them up within all of them, it's still stackable. You could still do a stackable if you want, as to your point, 8, 8, 8, and 6. You could stack them up one on top of each other, sure, but integrate them within the project rather than just being on the.
I mean, you just heard, Ed, I hear you, Ed provided an opportunity of a solution, and then Graham said he thought that was appropriate.
So that's what I'm saying, that's how you're asking me my opinion, and I'm giving it to you. That's what I think would be the fair way to do it, is if you integrate them within the whole building itself. You can still stack them, but put them in different places within the building.
So how could we word that to achieve something like that? How could we word that everything to try to break it up in that way? Is there a way to do that? And is there a way to word it?
Well, I'm not,
We're just having a discussion.
I don't know how we can,
Well, I guess could we say no more than X percent facing the exterior of the building? And, that will force the rest of them to be in the interior of the building. I mean, that's another condition.
well, I think we have we're mixing two different issues. One issue is disbursement. And disbursement, at least in my mind, involves a placement of units throughout an area, for lack of a better description. That's, for lack of a better word, a locational thing, a spatial thing, okay? When you move from a spatial thing, a spatial concept, into, well, they have to face the courtyard, or they have to face the street, or they have to face the shopping center, or they don't have to face the street, or they don't have to face the courtyard, or they don't have to face the shopping center, or they don't have to face the railroad. That's a different issue. That's not a disbursement issue. That's now getting into where you think these units ought to be, and your perception, I'm gonna say you, I mean the board's perception of, well, we ought to, a more desirable unit is here.
It's not
That
just
may
that.
be yours, but it may not be somebody
But
else's.
it's not just that. Isn't it the case that if all of the affordable units were on the exterior of the building, that makes them identifiable If you're in a unit on
But the entirety of the exterior of the
There's
building is not
there's
affordable, that's the
150
thing.
units.
predominantly it is, so.
But there's 150 units on 4 floors. If you disperse 8 units, maximum of 8 units on 3 floors and 6 on the other one, or however you may divide, no more than 8 on the floor. You know, you have, I can't do the math that quickly, but you have 120, I guess, roughly, 120 market units over 4 floors, right? So you have 30 market units on those floors. You know, maybe people are gonna be able to identify it, but, you know, when you look at the plans here, and you see that, I don't know how you would identify, well, this is an affordable unit, and this is the market unit, and this is an affordable unit, and that's a market unit. I don't know how you would do that, so look, if the view is that you can identify them, that's your view, and that's fine. I think factually, when you look at a building of this mass and this size on this site, certainly from the outside, it's my view that you would not be able to identify that. When you're if you're a tenant in there, maybe you will, maybe you won't. That I don't know, but I would find it challenging to think that you'd be able to identify it. If there's a concern that, you know, we have, as the mayor said, you know, 4 of the 8 units, let's say on the first floor, are the ones that face the railroad, and that's a concern. And remember now, just as an aside, nothing faces the railroad. There's a corridor, if I remember the layout, there's a corridor that runs parallel, so to speak, to the railroad. The doors are to the left if you're walking down the corridor. So you walk in, when you're in the unit, you don't see the railroad. You see it as you approach the unit, and I think there's windows there.
You hear it.
But, and you do hear it, but you don't see it. If there's a concern about that you think that, well, you know what, there ought to be no more than 2 units in that wing. If that's it, because you feel that those are less desirable, in spite of what I've said about desirability and non-desirability and what people think is and is not, that's fine. Then that's another component that you can put in. You know, no more than 3 units there.
Can I ask Maggie on the upper floors of that wing? I believe there are no units.
So it's
Is
hard
that
to
correct?
tell because these,
So we're saying
So-
it's undesirable, yet there's
One of
no
my-
market rate units.
one of my concerns is that, although Eileen, thank you very much for sending these, it looked as if things were cut and pasted onto the different floors, because some of the units had, like, for instance, this 4th floor plan has a couple of the 2 bedrooms with doors that open up. Well, it's not opening up to anything, so it looks like it was just a cut and paste, so I don't necessarily know if they were individual.
Theoretically, it's the same floor plan, because they provided testimony for the same. I agree that must be a mistake if there's.
But there's a lot of
doors
them,
there.
so that's concerning. We also had asked for layouts of some of these units, we still don't have those, we asked for those. How the affordable, for instance, how the affordable 3-bedroom, they have just the square footage, but they don't have the room layout. They don't have the floor, the plan layout. There's no, that's easy enough to throw, like, what does 3 bedrooms look like in that unit if they didn't do it? We asked for it many times, and in fact, I asked Eileen again, I've asked her a few times, I know I'm sure sent them asking them for that information. Like, what does that floor plan look like? And those aren't there, so,
Are they required to send that to us?
No, I was gonna say that.
I asked for it.
Well,
Be
I
nice.
understand
Well, you know
the
what it
answer,
is?
but I mean, in terms of,
You know
I
what it is?
appreciate, no, go ahead.
What I was gonna say is, and I can only go by when we were dealing with the Beehive, every time we asked for something from the Beehive, they were just very easy about it and took, listened to what the board had to say and made adjustments, and they were a pleasure to deal with. And they just, when we asked for different things from them, they did do it. So I just assumed that was what my experience was when
Sure.
dealing with the developer, that when you ask for things, they give them to you. And since our planner had asked for them starting in September of last year, I just assumed we would eventually get them, because Mr. Inglesino went on record, said he would provide it, and it wasn't provided.
So I hear that and I appreciate that, and specifically to the plan, I understand that. I just want to also go on record and say, in terms of working with this as a developer, we had requests regarding electric vehicle charging, and they heard us and they came back and made changes. We had concerns about the stoops. They came back and offered us, you want them, you don't want them, we'll do what we want. We made different conditions and concessions on move in and move out and what they can put in their lease, and they heard us and offered to make concessions. So to say that they're not working with us and just saying evaluate it is what it is and you get what you get is not a fair characterization, I think, of this developer.
Well, and it also would help them in terms of the stoops, because then they don't need a variance, so that's inures to their benefit.
I'm just saying they heard our concerns and came back to us and were willing to address them in some cases.
Benefits, yeah. Anyway, so you were saying, I mean, I can show you if you want to see the plans, I don't know if you brought your copy or not. So do the units go above it? I believe that they.
I believe they do not.
I can't tell because
They
you
do not.
see,
So-
they were cut and pasted, so you can't, I don't know, that's the problem. These aren't, they're not each floor's units.
Can I, and with all due respect, I'd just like to add something here. I think we're trying to do something that we asked these applicants to do for us. And that was, we're not happy with the integration of these units, and they didn't respond by addressing that, okay? So we're going through this exercise, not even knowing whether or not they'll accept this or not. So I've been present when we've asked them multiple times if they would integrate these units more. To me, my thing is, they're the professionals. They know the architect, they know the building. So who better can place and disperse these units than them? But they chose not to. They have chosen not to up to this point.
Sure.
Now, we are going to spend hours and hours trying to come up with a plan that we asked them to come up with. And whether they want it or not, I think we are wasting a lot of time on something that we can't come to a conclusion in a minute's notice to come up with what they should have come up with us when we asked them.
So I appreciate that. Can I ask Ed to just re-highlight for us the process that the applicant would have? So say we chose to deny an application based on the location of space. I think you said it before, but I think it would just maybe be helpful for me, maybe somebody else. If we were to, then what would the potential recourse be, and who would make that determination? Would it be fair share? Would it not be fair share? You know, because we had them weigh in on the issue and we heard no major objections, it looks okay, but then you said they aren't the ones making the rules. So I just would like to hear, if we were to deny it, I don't know if that would be helpful to hear who would sort of be the one to evaluate whether we are justified in that or not. Would that be?
Well,
That would be
I'll give you the
helpful.
process. I'm not going to,
Okay,
I'm going to stay away from the legal analysis.
Sure.
But the process is, if the board denies the application, and the reason for denying the application is that the integration plan is, for all intents and purposes, a segregation plan. And
if that is the case, yeah.
emphasizing the point.
Hypothetical.
I'm not suggesting that it is or is not. But on the basis that the integration plan is inadequate and does not achieve the results that were intended by the regulatory provisions that I cited to you. And therefore, we're going to deny the application. The applicant would have the right to challenge in court, to sue the board on that denial, saying it was arbitrary, capricious, and unreasonable, that you deny the application based upon this component. And I would suspect they'd argue, it does meet, the component that they presented does meet the requirements that are set forth, and that I gave you as standards. And that the board's decision should be reversed. That the board's decision was arbitrary, capricious, and unreasonable, that the decision should be reversed, that the court should approve the application and go forward. The court would then look at the record, which is what we're doing right now. What we're talking about now would be before the court as what would be all of the hearings, court will look at all of that and make the determination as to whether or not the board's denial was arbitrary, capricious, and unreasonable. And if the court found that it was arbitrary, capricious, and unreasonable, the court could either remand it to the board to approve the application, or the board or the court could approve the application because they looked at the component that was the basis for the denial and said, you can't do it on that denial, so therefore your decision is reversed and the applicant will be able to move forward. Or the court could look at it and say, yes, that is the board's decision was not arbitrary, capricious, and unreasonable, because this plan does not meet the criteria, the measurement, and therefore the board's decision is sustained. The point that I made earlier was that if an application is deficient in some distinct, discrete area, in most cases, the manner in which a board should handle that is to impose a condition that deficiency be remediated in some way. And, sometimes it's engineering issues, which are, more objective. Sometimes it's other issues. But that's the manner in which you should address what you believe to be a deficiency in the plan. It's not the plan that is objectionable, it's a component of the plan, it's some aspect of the plan. And again, you have to be careful about the tail not wagging the dog. And in any matter, not just this one, if we have other applications, there may be some particular item that you're concerned about. Well, the way to handle it is to address it in some way, so that, and if the applicant disagrees, they can disagree, but at least you've not thrown out the baby with the dirty bath.
Okay.
Sure.
Wait a minute, I have a quick question, I'm sorry. Is there a third option, and that is that this developer agrees to partner with the town and is hearing us today, and we postpone our vote until they meet the requirements that we've been asking them all along? Is that a third option?
That's something that
Well, they've already rested, so I don't know if that's an option or not. So that's why I'm asking you for legal advice. If that's another option, it's a less, how do I want to say, aggressive option. That's what we've been asking for all along, to partner with them. So, and we've asked them for this information over and over again. And I'm just leaning on two specific. One is the segregation of the units, and also the drawings that, I'll be honest with you, from HPC, these would not be acceptable because they're not complete. And they're insufficient. They've met all the requirements, but they're insufficient of what we've asked them for. So clarification on that. So is there a third option here, or because they've already rested, that's eliminated that option?
I think there is a third option if the applicant is willing to do that. And the other thing is, I want to be clear about this. The board can ask for anything it wants to ask for. The applicant doesn't have to give the board anything it asks for. The applicant needs to give the board what the ordinance requires. We start out with a complete application. That's that checklist that Martha goes through, and Eileen goes through, and Brandon goes through, to deem the application complete. So once it's deemed complete, the materials that we need in order to address the application have all been assembled. That's what that whole process is about. So we don't have somebody submit whatever they want to submit, then we start looking at it and say, well, what about this, and what about this, and what about this? So we have a whole checklist of pages of things they have to do that are looked at before it ever gets to us. The fact that we may request things, and we do all the time with applicants, and the applicants supply them, that's fine, and that's the way this process should unfold. But if an applicant gives us something and we say, well, that's not what we wanted, and the applicant doesn't give us anything else, you may be offended by that, because they said they were gonna do it, or you thought they said they were gonna do it, or maybe there was a miscommunication, maybe there was no miscommunication at all. The applicant just says, you know what, I don't want to do that. I've had it, I've done enough, We can't deny an application because an applicant doesn't give us something that we asked for unless it's something that is required under the ordinance that governs, the zoning ordinance, the land development ordinance that governs our evaluation of an application. And unless I'm mistaken here, and I could be, and I'll certainly stand to be corrected by Graham or Martha or anybody else, we got all of the things that the applicant was required to give us under the ordinance. Further, if there's something else that we feel is so critical to a determination, to having something, then I go back to the solution with the integrated units. You impose a condition, provided that the applicant, condition the applicant shall, and we have a condition in, I have a list of 32 conditions that we talked about, or that I've developed through the materials that have come forward from our professionals. But we have a standard condition that the applicant shall revise the plans to the satisfaction of the planner and the engineer, because those are the plans that are actually signed. At the end of the day, the applicant produces a set of plans that are reviewed carefully by the staff, by the professionals, not me, thankfully. And a determination is made, yep, those plans reflect what ought to be there. Those are the plans that the chair signs, those are the plans that Eileen signs. I think the township engineer signs, there's a whole variety of people who sign these plans. That's when that's done. So that's another thing that can be, if the plans are incomplete, and I use incomplete, Allison, the same way you were using it, not technically, but just inadequate in your own form, then say what you have to do, and put that in as a condition.
So as a professional, what we're asking for here, or what I've been asking for, do you find it fair and unreasonable to ask for those pieces to be fulfilled? I guess what I'm saying, in a court of law, I don't think Fair Share Housing would find it unreasonable that we're asking for plans that are fully integrated with, and I don't think that it's unreasonable to ask because the definition is not clear in their wording. I don't think it's unreasonable for us to ask the applicant, okay, because does it not read that basically?
Allison, I just want to clarify, because we did ask the applicant, we raised this as a concern, and they provided testimony of how they specifically came back. We might not like the answer, some people might not like it, but they did come back and give us an explanation for why, no justification. So
I understand.
I feel like we made the request and then we got a response.
But as a majority, which we won't know, but is it an unreasonable ask in your opinion, or, and maybe you might not want to answer that, but what I read here is the fact that the FSHC would not challenge any approval granted by the planning board. So to me, clarification on that granted is, if it's not an unreasonable ask for us to make an informed decision, then can we not ask to postpone this with the request that we're making? I feel secure that this isn't an unreasonable ask. Whether they give it to us or not, that's up to them. But I don't think it's an unreasonable ask. And I think affordable or fair share housing would not think it's an unreasonable ask. And if I remember, and I don't have the exact wording, but at the last minute, when Ms. Miggins asked the developer, and forgive me, the name has left me, I'd have to look through my notes. When she asked if there was any way that he could disperse these affordable units, he said, why would I? And to me, that's not answering the question appropriately. So, and I don't think it's unreasonable to ask.
With regard to postponement, let me just comment on that. There are time periods, time limits within which we are required to act. And we have a time limit, I believe today was the extension of time that we have. So it's, if that time limit weren't there, that would certainly be something that the board could consider, you know, because we have control of the calendar, so to speak, and we can say, well, you know what, we want to postpone this for this. We can't do that in this case without the applicant's consent. If the applicant consents, we can postpone it. But without the applicant's consent, we have to take a vote on what we have.
I just want to say, you were saying that providing, we could change the providing the full plans as a condition. But the problem that I see is that, impose that as a condition. The problem that I see is that we're not asking for the full plans just for the sake of asking for them. We're asking for them so that we can look at them and make some determination about what they say. If we impose them as a condition and approve it and impose that as a condition, and then they do provide the full plans, it's too late. We've
What is
already
there that we
approved
need
it.
from the full plan that we don't have to make a decision now?
Really?
I guess that's what I don't understand.
The layouts of the
layouts
property,
the
that
the
just,
square
how do you
feet of-
prove something when, you have doors opening up to courtyards on the third or fourth floor? These are not,
I think we have enough information to make decisions.
I understand, but I don't want to sign off on something that are incorrect. That's just, I won't do it.
Right, and that's why the condition would be imposed, these must be revised to,
Yeah, I guess with regard to the layout of the units, for example, thankfully, that's not my job to look at the plans and look at 149 units to see what's laid out there. But the reality is, if they had 149 units there and didn't have anything inside there other than 1 bedroom, 2 bedroom, 3 bedroom. I'm not sure, and I'll defer to Graham and I'll defer to Martha, whether that, we could say, well, that's not complete. You don't have each unit laid out, it's typically done. And I believe it was done here, at least some of them that I looked at, if there was some missing that somebody committed an error and those can be plugged in. But I guess my point is, if there are 15 of those units in these plans of the 149, that there's no delineation of bedrooms or kitchens or bathrooms or whatever. And we say, well, you have to plug that in, you have to put it in. They'll put it in. We can't say to them, well, we think this bedroom's too small, we think this bedroom should be over here, we think the kitchen should be here, we think the entrance should be here, we think it should be flipped around, we think there should be more windows here. That's well beyond whatever we do. We look at the concept of the building, the layout of the building, all the things that we've done. I mean, I have to go through, you know better than I know, because you look at it much more carefully than I look at it from the attorney's point of view. Of what's there. So if there's something missing, and perhaps to the chair's question, what is it that we want to have that would affect the decision that we make? We don't make a decision as to here's how the bedroom should be configured, or here's where the doorway should open. That's not, we may make suggestions about that when we look at it, but that's not our role here.
But Mr. Buzek, isn't that exactly what Graham did? in the preliminary when he told them that this is what we'd like to have? Because I'm not, I'm not an architect. But to me, looking at prints, this is for the record. And I'm looking at 100-year-old prints. Okay, so they do have to be anchored. This is in history. This is locked in as they have said it was going to be. Forgive me, and certainly you can ask Graham the same question. But this is just as important as any legal document in this whole application.
So I agree. I wasn't, I'm not undermining it. What I said was that before the chair signs and the engineer signs and the secretary signs and anybody else who signs off on these plans, they will have to dot the i's and cross the t's that need to be crossed, that need to be dotted, need to be crossed if they're not. And Mr. Cohen's question was, well, what good is that for us? Because we don't see that. We're saying they have to do that, but we don't get the opportunity to look at it and see those revised plans. And the question that I pose is, what's missing and do we have jurisdiction over that? And as far as I know, what's missing are things that we don't have jurisdiction over.
But Mr. Inglesino had said he would provide it to us.
And they provided what they provided. If they didn't provide it, they didn't provide it. And that's it. Mr. Inglesino doesn't get punished because he says they're gonna provide it and they don't. You may be upset with him. That may not be what he should do, but, this is not a personal, affront. We can't take it that way. That's Mr. Inglesino's issue, if he made representations that he doesn't fulfill. And I'm not suggesting he did or he did not. I'm just saying that those are not issues that impact on the decision that we make.
Graham,
I just want to make one,
if you clarify, you're responding to.
my comment letter from September has been referenced to a couple of times, and I just wanted to explain the nature of the request that we had indicated in there. On the submitted plans, the original submittal set, there are 3-bedroom units that do not have interior configurations, and they range in size from 1,200 square feet to 900 square feet. And it was just a request that we see that configuration and confirm that a 3-bedroom unit could fit within that. 3 bedrooms are required as an affordable component of this project. So that was the nature of our request, to confirm compliance with the affordable housing, to make sure that those can fit. We've seen it before where you may get to construction or going into the final construction plans and oops, now it doesn't fit. So that's why I wanted to see that.
And in your response to the question, you hadn't seen it.
I just wanted to,
You hadn't seen that configuration.
as far as the exhibit that was submitted afterwards, correct? Yeah, and then
Did
they
you
were
see them, did they supply anything that demonstrated, that answered your question? Because again, Graham, I didn't evaluate those things.
I haven't seen the exhibit set. I didn't receive that exhibit set. I don't know if those 3-bedroom units have shown an interior layout. But that was the nature of it.
They have not. Just square footage.
I'm just saying this, earlier on, asked for a recess to talk to me.
Sure.
I don't know if he still wants to do that, but if he does, I would suggest that we take a 5-minute break.
Is that something you would still like?
Yeah.
We'll take a 5-minute recess. Let's be back at 9.
session. We, just for the record, want to announce Sujatha, who was going to recuse anyway because she did not participate in one of our meetings, has departed. So 9 p.m. She has left the meeting. Welcome back.
Thank you. I did have a conversation with Mr. Inglesino. What he proposed, or what the applicant proposed, was that if the board is not satisfied with the integration plan that was set forth in the plans that we've reviewed, that the board condition an approval on the approval of that integration plan by the special master, who's Frank Banish. The special master is appointed by the judge in the course of the declaratory judgment proceedings to advise the judge on various issues. He's a planner, most of the time they're planners. Frank Banish has been involved, from the outset of this case, of the litigation, the declaratory judgment litigation, and is familiar with these kinds of issues because he's special master in other places as well.
And in special master on other cases in Milburn as well?
No.
Okay.
Other declaratory judgment cases handling these kinds of issues.
He has all the Milburn cases.
That's what I thought. That's what I said. He did all the Milburn cases.
Yes, he did
Yes.
these Milburn cases, yes. And, the judge will likely seek the special master's input anyway in terms of what they, what the judge will ultimately decide. Doesn't have to follow the special master, but he would likely ask for the special master's input. I have not spoken to the special master about this plan or this issue, so I can offer nothing further about that. And
Can I just ask you to repeat, because you just said there we could potentially impose a condition that it would have to be approved by the special master, and then you said he probably would look anyway, that you don't know if they would have to.
Yes,
I want to make sure I followed you.
yes, I'm sorry.
That's okay.
I did sort of shorthand that, so let me be more specific. If we approve the application and impose a series of conditions, one of which would be that, then we would effectively defer to the special master to make that determination in this matter.
In this matter, which kind of goes to where Allison's question of looking for somebody with appropriate advice. Okay.
If we were not to do that, and we either if we denied it without any kind of condition, if we denied it, the special master would likely look at the basis for the denial and give the judge advice. If we approved it subject to a condition, and that condition, a condition that they, as we talked about, integrate the units differently, that there be no more than 8 on the floor, however we structured that, and that were challenged, the court would have the special master look at that and advise the court on it. That's what I meant by.
Understood.
I did jump around a little bit.
So I just have one question. If by giving it to the special master, whatever he determines or deems, and it could be this plan stays as it is. Because
Yes.
it takes it out of our hands to make that decision. So if we go directly to him, then we've lost basically all control of that.
Correct. That's correct.
If we're saying we are not comfortable with it because we don't feel that it meets the letter of the law, so we're asking them to determine and make an assessment on what is.
Right. But could we also put in a stipulation that we would like him to review this and disperse the units? Because the board prefers to disperse the units in a more appropriate and integrated manner?
Yeah, I think that the condition could be, the board could set forth its position, and it could be to defer to the special master. And in the condition, set forth the reason for the board's determination and what it feels it ought to be. I think it's a
But he could deny it too.
Yes, he can.
You could deny that.
Can I
Let me,
ask
can I just also point out that this is the same special master that insisted that when the settlement was negotiated, that no discussion was allowed outside of the room, which got us into all sorts of issues. I mean, I wasn't on the township committee then, I wasn't a part of it, but, you know, that was the start of all sorts of problems where many people feel there wasn't enough public input into the session. So ceding that control to the special master is not something that is appealing to me whatsoever.
Or me.
Okay, go ahead, Diana.
And I'm just following up on how you sort of started this conversation, which was sort of talking to us about not ceding our control, you know, whether it's Fair Share or somebody else. So I would assume that the special master would also be someone who might fall under that category of who you should not be ceding to.
Any delegation by you, whether it's the special master or it's, you're exactly right.
I listened to you.
So clarification, the client or the developer is not entertaining option, and that is to partner with us, postpone this, get us the proper disbursement, get us a better set of plans, and we vote on it at another time.
That offer was not made.
Thank you.
So there's a motion on the table.
There is a motion on the table. That was your motion.
My motion. Allison seconded.
That would be a denial of the
Yes,
application.
and my
Also.
only comment is, not surprising, is that I would ask the board to think about alternatives to that, as I've now.
Do you think about the alternatives before we vote or after we vote?
Well, if I
If you
wanted to
don't
give-
deny it, it doesn't mean you approve it, it means we would still have discussion. Is that correct?
That is correct.
Sorry, come again?
It's not,
Yeah,
not denial, doesn't mean you
It's not
approve
an
it.
If you don't approve it, it's a
If you don't.
denial,
Right, but if you don't.
okay?
But if
But
you
if you
don't
don't
deny
deny
it,
it, it's not. So you won't.
so we would still,
So
we
you
could
then
still
have
talk
to
about
deal
it.
And we can talk about it, and if we do have certain conditions, even though the applicant does not agree with them, we can still put those conditions on the approved application, is that correct?
That is correct.
And
We
if
have
they choose
control
not to
over that.
meet with them, then they would have to take different action.
That's correct.
So would it be appropriate for us to take a vote on the motion and second? at
Well,
this
if the mover and the second, are not willing to withdraw or do not want to withdraw, that's fine.
You also shared with us at the beginning when it happened, you felt you needed to have enough of an explanation and understanding of where they were coming from. Do you feel you have that?
Well, as far as I can tell, we're talking about the two things. We're talking about an integration plan that is inadequate, and secondly, that the plans that are before us are not fully, I don't want to use the word complete, but that's the word that just keeps coming. Are insufficient in some aspects, and therefore that we are unable to approve the application in that form.
Mr. Buzak, just to make the record clear about the other part of our conversation and the other condition that we agreed to. There was, the condition would be that to the extent.
Oh, yes, I'm
Yeah.
sorry, I'm sorry. I
Go ahead,
And Mr. Ingleson was right. The other aspect was that the 3-bedroom units that don't have the configuration that show 3 bedrooms and where they're located. If you look on the plans, it just has, the unit says 3 bedrooms, but there's no
Right, then you
delineation.
noted.
They would agree to a condition that those plans be revised to include the delineation of any unit that does not have a delineation on it.
And I know I'm just repeating myself, but they're not agreeing to controlling the segregation or the disbursement of what we're considering
That's
certification. They have denied taking control of that and presenting that an additional.
In their view, what they presented is adequate and meets the letter of the law.
Okay, the motion was to deny.
Right, so if you vote yes, you're saying deny the application.
Allison Canfield,
Yes.
Michael Cohen,
Yes.
Maggie Miggins.
Yes.
Deborah Nevis,
No.
Srini Vijay,
Yes.
Michael Zion,
Yes.
Gaston Halbert,
No,
Beth Zoll.
No,
Tonight.
the application is denied.
5-3 is my count here,
Yes.
right?
Yes, I see.
Okay, we'll prepare a resolution for consideration. We have to do that within 45 days. What, our next meeting is August, right?
August, 16, yes.
Yeah, August
16.
16?
No,
I have it right here,
application,
sorry.
just 3 ordinances.
And we'll have to do, August 16th, yeah. Okay, so application 22003 was denied. Our next meeting is here, August 16th. I move to adjourn. Second.
Second.
All in favor?
Aye.
Meeting's closed.
that's the longest deliberation that I've ever done.
Was it?